So, right now, there is a bill that's currently pending in the Pennsylvania General Assembly. In the House, it's called Bill number 1532. And in this bill, it is basically trying to set up different standards for what is going to be considered inappropriate for teachers to cover in school. What we'll be doing today is basically just doing a very close reading of this particular bill to see what the implications are and just to be aware of what it is that's going to be promoted and again, it's actually pending in the Education Committee of the Pennsylvania House right now. Okay, so first up, we have Section 1 of the bill, which is the short title, and it reads An Act providing for restrictions on racist and sexist concepts for contracts, for penalty, and for private cause of action. This act shall be known and may be cited as the Teaching Racial and Universal Equality Act. So sometimes what the words mean in a particular bill or statute isn't necessarily what the common understanding is, so it's always very important to look at the definitions. And here we go with the definitions. So Section 2, Definitions. The following words and phrases, when used in this act, shall have the meanings given to them in this section unless the context clearly indicates otherwise. Contractor. An individual, organization, or corporation or business of any kind that enters into a contract or a subcontract pursuant to a contract with a Commonwealth, county, or municipal agency, public school district entity, or public postsecondary educational institution. Postsecondary institution. As defined under Section 2001-J of the Act of March 10, 1949, PL 30, number 14, known as the Public School Code of 1949. Public postsecondary institution. A postsecondary institution that receives funding in any amount from the Commonwealth. Racist or sexist concept. Any of the following concepts. 1. One race or sex is inherently superior to another race or sex. 2. An individual, by virtue of race or sex, is inherently racist, sexist, or oppressive, whether consciously or unconsciously. 3. An individual should be discriminated against or receive adverse treatment due to the individual's race or sex. 4. An individual should receive favorable treatment due to the individual's race or sex. 5. An individual or institution cannot or should not treat individuals without regard to race or sex. 6. An individual's moral character is determined by the individual's race or sex. 7. An individual, by virtue of the individual's race or sex, bears responsibility for actions committed in the past by members of the individual's race or sex. 8. Meritocracy or merit-based systems are either racist or sexist. 9. The United States of America or the Commonwealth of Pennsylvania is fundamentally racist or sexist. School district, as defined under Section 102 of the Public School Code of 1949. Next up, we have Section 3, Communication and Actions by Public Entities. A. General rule. No communication by a Commonwealth, county or municipal agency, school district, or public post-secondary institution, or an official representative shall adopt, express, or promote any racist or sexist concept. B. Penalty prohibited. No employee, contractor, staff member, or student in a Commonwealth, county, or municipal agency, school district, or public post-secondary institution shall face a penalty or adverse treatment due to a refusal to support, believe, endorse, embrace, confess, act upon, or otherwise assent to a racist or sexist concept. C. Use of funds prohibited. No Commonwealth, county, or municipal agency, school district, or public post-secondary institution shall use any funds to express, publish, advertise, or promote any racist or sexist concept. Section 4. Educational instruction at schools and public post-secondary institutions receiving public funds. The following shall apply. No instructor, teacher, or professor at a public school district or public post-secondary institution shall 1. Teach, advocate, or encourage the adoption of a racist or sexist concept while instructing students, or 2. Penalize or treat adversely a student who refuses to adopt or express any racist or sexist concept. Subsection 2. No public school district or public post-secondary institution shall 1. Host, pay, or provide a venue for a speaker who espouses, advocates, or promotes any racist or sexist concept, or 2. Require a student to read, view, or listen to a book, article, video presentation, digital presentation, or other learning material that espouses, advocates, or promotes a racist or sexist concept. Section 5. Requirements for public contractors. A. General rule. A contract entered into by a commonwealth, county, or municipal agency, school district, or public post-secondary educational institution with a contractor after the effective date of this section shall include the following provision. During the performance of this contract, the contractor shall not engage in workplace training that teaches or encourages the contractor's employees to engage in any form of the following racist or sexist concepts. 1. One race or sex is inherently superior to another race or sex. 2. An individual, by virtue of the individual's race or sex, is inherently racist, sexist, or oppressive, whether consciously or unconsciously. 3. An individual should be discriminated against or receive adverse treatment due to the individual's race or sex. 4. An individual should receive favorable treatment due to the individual's race or sex. 5. An individual or institution cannot or should not treat individuals without regard to race or sex. 6. An individual's moral character is determined by the individual's race or sex. 7. An individual, by virtue of the individual's race or sex, bears responsibility for actions committed in the past by members of the individual's race or sex. 8. Meritocracy or merit-based systems are either racist or sexist. B. Noncompliance. In the event of a contractor's noncompliance with the requirements of this section, or with any rules, regulations, or policies that may be promulgated in accordance with this section, the contract may be canceled, terminated, or suspended in whole or in part, and the contractor may be declared ineligible for further government contracts. C. Contract requirement. A contractor shall include the provisions of this section in each subcontract so that the provisions shall be binding upon each subcontractor. Section 6. Enforcement. A. Investigations. The Attorney General may investigate any complaint by a resident of this Commonwealth that a Commonwealth, county, or municipal agency, school district entity, or public post-secondary institution has violated a provision of this Act. B. Publish conclusion. The following shall apply. 1. If the Attorney General, after conducting an investigation of a complaint under subsection A, finds that the Commonwealth, county, or municipal agency, school district entity, or public post-secondary institution has not violated a provision of this Act, the Attorney General shall publish that conclusion and underlying findings. 2. If the Attorney General, after conducting an investigation of a complaint, concludes that the Commonwealth, county, or municipal agency, school district entity, or public post-secondary institution has violated a provision of this Act, the Attorney General shall 1. Publish the conclusion and underlying findings, and 2. Order the cessation of the transfer of Commonwealth funds to the violating entity or institution for the remaining of the fiscal year and for the entirety of the next fiscal year. C. Appeal. An entity found to have violated this Act may appeal the Attorney General's determination in the appropriate court of common pleas. Section 7. Private cause of action. The following shall apply. 1. A resident of this Commonwealth shall have standing and a private cause of action to file a civil complaint in a court of common pleas against a Commonwealth, county, or municipal agency, school district entity, or public post-secondary institution claiming that the entity or institution has violated a provision of this act. 2. If a court finds that the Commonwealth, county, or municipal agency, school district entity, or public post-secondary institution has violated a provision of this act, the court shall enjoin the violating entity or institution from receiving funding from the Commonwealth in the following fiscal year and shall award costs and attorney's fees to the complainant. Section 8. Severability. The provisions of this act are severable. If any provision of this act or its application to any person or circumstance is held invalid, the invalidity shall not affect other provisions or applications of this act, which can be given effect without the invalid provision or application. Okay, so now that we know exactly what the bill says, let's dig a little bit deeper into some of those sections that kind of gave me pause. But you know what? First, let's get something just kind of out there on the table. I think that a bill that wants to proactively take measures against racism and sexism, that's a fundamentally good thing. I don't think that we're going to find very many people who are going to say, oh, fighting racism is bad. But that's where getting into the definitions of what they mean by racism is really something that's important. When we look at that definition, as far as what a racist or sexist concept is, I think that we can all agree that, one race or sex is not inherently superior to another, that, that someone by virtue of race or sex is inherently racist, sexist, or oppressive. But I think that where we're getting into a little bit more trouble, where we want to look a little bit closer, is the entire definition of favorable treatment. When you're looking in the definition of the race or sexist concept, number 4, talking about favorable treatment, what exactly do they mean by favorable treatment? Are we talking that if someone was discriminated against, or if there's like an affirmative action situation, that is now something that's prohibited under the statute, that's considered to be racist, even though the U.S. Supreme Court hasn't gone that far? I don't know. That's an interesting question. And that's where looking at the law as you're reviewing it yourself, just kind of take a look for these other terms where they can be interpreted in a way that's inconsistent with existing precedent and current notions of what's considered to be fair, and basically creating more of an even playing ground and making up for past discrimination and even ongoing discrimination. When we're saying that under Section 5 of this definition, that an individual or institution cannot or should not treat individuals without regard to race or sex, that takes us back to that question of, okay, if we're noticing that there's still segregation going on, that we're still trying to remediate past discrimination, does this particular part of the definition mean that trying to make up for past discrimination is now considered racist? It's an interesting question. I think that it's one that the Education Committee should probably dig into a little bit deeper. Now, looking at number 8 of this definition, as far as meritocracy or merit-based systems are either racist or sexist, what really jumps out about this particular part of the definition is that it's making a conclusion about meritocracy that it's just not racist. That's something that I think that most experts would say it's arguable. So for a bill to come out and just say that the idea that meritocracy is racist is in itself a racist principle, that's unnerving and that's troubling, because that leads to the potential outcome that a teacher who's trying to get students to get a little bit closer into the history of what a meritocracy is defined as today, looking into the potential racial and sexist elements of that, I think that's very important. If we look back into our history and see what the definitions of meritocracy happens to be, there's an argument there that the way that we are implementing this merit-based system can in fact possibly be racist. So to say that that particular analysis is automatically racist, that's troublesome, and I think that, in my personal opinion, that may undermine the purpose of an education, which is to teach students to investigate and think things through. Now, as far as number 9, the idea that the United States of America or the Commonwealth of Pennsylvania is fundamentally racist or sexist is under this bill being turned into a racist or sexist concept. That's special. That's very special. It's also something that is cutting off the opportunity for actual academic inquiry and independent thinking. So, these are things that, again, let's take a little bit of a closer look at to see if that's actually something that should be passed into law. So, when we're looking in a little bit further as far as the Section 3 and Section 4, some of these interesting things that we're looking at is the limitations on the ability to express certain concepts and ideas. Now, as far as it's like I said with the definitions, saying that all races are equal and that anything to the contrary is racist, okay, that's cool. But when we're saying that no one who works for one of those agencies shall express any idea as far as questioning whether there are racist or sexist elements to meritocracy and whether the United States or the Commonwealth of Pennsylvania are themselves racist, that's troubling. When we're getting into that idea that they can't express or at least explore those ideas, that's a pretty big red flag. Going back into the inability to host someone who's promoting what's considered to be a racist or sexist idea or concept under the statute. That means that if you have someone who is talking about critical race theory and how meritocracy has been used in a racist fashion in the United States, that means that person is not going to be permitted to come into state universities or local schools to speak. And that, again, is something that's a little bit of a red flag. We need to look a little bit further into that. So if you go back and see, it looks like they're saying that a resident of the Commonwealth shall have standing. So what standing means is that in order for you to go and sue for something, the courts don't just want any, random arb off the street suing for any old reason. It's a waste of resources. It's unfair for whoever has to defend the claim to just fight anyone who just wants to go into court. So what that means is that you have to have standing. You have to have a strong enough tie to the subject, or otherwise a law has to give you that ability to go into court. So ordinarily, you have to be someone who is harmed or has an interest in a case in order to actually bring a suit. Now, the cute little thing this bill does is that it makes it so that any resident would be able to file a private suit against any entity in the state. So you can have someone who's out in Fayette County but has an issue with what's being done in Pittsburgh public schools, and they'll be able to file a suit in order to try to get that injunction and to get those costs and filing fees and those attorneys' fees back for something that doesn't affect them or their children or them as taxpayers. So again, it's something that it's very interesting. Ordinarily, you don't see standing given to someone who doesn't have skin in the game, so to speak. So that's, again, just another part of this particular bill that makes it a very interesting and potentially dangerous avenue for harassment by lawsuits. So, after hearing all of this, you might be asking, what do you do now? Now, I'm not going to sit here and say that everyone who has gone through this video and has read through the statute should just go and contact their local representative to tell them to fight this. Hey, if you agree with it, then it is your right as a Pennsylvania citizen, as Pennsylvania resident, to contact your local representative and say that you support it. But if you're someone who disagrees with it, you have that particular right and to a certain extent, a little bit of a duty to reach out and let your representative know that you do not approve of this. Now, it's been sitting in committee for a year and a few days now, but that doesn't mean that we shouldn't let our representatives know that even if something looks likely to be vetoed by the current governor, that this is not the type of law that we as voters want to see. So, like I said, whether you agree with this particular bill, you disagree with it, pick up the phone and call your local representative. Yes, I know you can send an email, but there's something to be said about actually picking up a phone and talking to a live person about what you think about this particular bill. It's important because we want to make sure that students in Pennsylvania are learning truth, that they're learning factual history, that they're getting things from all sides. It's one thing to be putting forth ideas that are disproven and shown to be false and are otherwise bigoted. It's another entirely to remove certain things that a particular legislator and people who co-signed on to this particular bill think that they don't want to have taught in schools. The way that we create thinkers is by exposing them to as many facts as possible and leaving it to them to come to their own conclusions. If you give students all sides of the history of meritocracy and how the United States got to where it is and how the Commonwealth of Pennsylvania got to where it is today, give them the options of determining whether they think that these things are racist or not, or sexist or not. It's not necessarily the place of government to be dictating how people think. And unfortunately, under certain parts of this particular bill, there's a solid argument to be made that they're doing just that. This is Leah at the Tiny Bookstore. Thank you very much for listening to this video today. And just remember, go out and do something. And making that phone call today isn't going to be enough. You're going to want to follow up every single month until you see the change that you want to happen. Have a great day.